Rồi, ok, thấy được rồi nha.
Dạ. Hi everyone, we are group 2 and we will present section 8 trademark. There are 4 people in my group, Khánh Vy, Phương Lâm, Thanh Trúc and me. This is our group table of contents. And I will present the first part. Question 1. Describe the condition for a trademark to be protected under the intellectual property law compared to Chinese, Japanese law. The condition, a mark shall be eligible for protection when it satisfies the following conditions. It is a visible sign in the form of letters, words, drawing, or image, including holograms or a combination thereof, represented in one or more colors. The sign shall be ineligible for protection as much stipulated in Article 33. It is capable of distinguishing goods or services of the mark owner from those of other subjects. The condition for a trademark to be protected under trademark law of the People's Republic of China. Article 8. Any visual sign capable of distinguishing the goods or service of one natural person, legal entity, or any other organization from that of others, including any word, design, letter of an alphabet, numerals, three-dimensional symbol, combination of colors and their combination, and application. Article 9. Any trademark in respect of which an application for registration is filed shall be so distinctive as to be distinguishable and shall not conflict with any prior right acquired by another person. The sign shall not be used as trademarks stipulated in Article 10(11) of this law. The condition for a trademark to be protected under Act on the Protection of Trademarks and Other Signs, 1994 of Germany's law. On signs, particularly words including personal names, designs, letters, numerals, sound marks, three-dimensional designs, the shape of goods or of their packing, as well as other grouping, including colors and color combination, may be protected as trademarks if they are capable of distinguishing the goods or service of one enterprise from those of other enterprises. Signs consisting exclusively of a shape, which result from the nature of the goods themselves, which is necessary to obtain a technical result, or which give substantial value to the goods, shall not be capable of being protected as trademarks. The condition for a trademark to be protected under Trademark Act 1959 of Japanese law. Any trademark used in connection with goods or service pertaining to the business of an applicant may be registered unless the trademark consists only of a mark indicating in a common manner the common name of the goods or service. Anything is customarily used in connection with goods or services consists only of a mark indicating in a common manner a common surname, name or name. Consists only of a very simple and common mark. However, it also stipulated that notwithstanding the preceding paragraph, a trademark that falls under any of items 3 through 5 of the preceding paragraph may be registered if, as a result of the use of the trademark, consumers are able to recognize the goods or services as those pertaining to a business of a particular person. Conclusion: Vietnamese law on intellectual property has similar regulations with other countries' law. Question 2. What is a well-known trademark under the intellectual property law? Compare with foreign legal regulations on criteria for evaluating a well-known trademark. Legal concept well-known trademark is not defined in the Paris Convention, TRIPS Agreement, and Weibo Chon Recommendation of 1999. It appears that there are very few jurisdictions in the world define what well-known trademark, famous trademark is in their national legislation. Even the world's most populous country as China also does not define what well-known trademark is in its trademark law of 2001, but it only gives a definition of well-known trademark in the subordinate legislation. For example, Order No. 5 guiding the implementation of the 2001 Chinese trademark law define that a well-known trademark is the trademark known widely by the relevant section of public and earning a high level of reputation in China. By the enactment of the 2013 trademark law, in Order No. 66 guiding the implementation of the 2013 trademark law, the factor reputation had been removed, according to which well-known trademark is trademark known widely by the relevant section of public in China. In contrast, India makes a long definition of well-known trademark in subparagraph Article 2 of Trademark Act of 1999. Well-known trademark in relation to any goods or service mean a mark which has become so to the substantial segment of the public which uses such goods or receives such services that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering of service between those goods or services and a person using the mark in relation to the first mentioned goods or service. For Vietnam, definition of well-known trademark is found in Clause 20, Article 4 of the 2005 Intellectual Property Law, stating a well-known trademark means a trademark that is widely known by consumers throughout the territory of Vietnam. Article 6 of the 1967 Paris Convention for the Protection of Industrial Property requires member countries to afford certain protections to well-known marks, regardless of whether they are registered. Specifically, member countries must provide the means to refuse or cancel the registration and prohibit the use of a well-known mark when applied for or used by an unauthorized party for indenture or similar goods when its use or registration would likely cause confusion. Criteria for well-known trademarks should be taken into account when considering whether or not a mark is well-known under the 2005 Intellectual Property Law. The number of relevant customers who were aware of the mark by purchase or use of goods or services bearing the mark or from advertising. The territorial area in which goods or services bearing the mark are circulated. Turnover of the sale of goods or provision of service bearing the mark of the quantity of goods sold or service provided. Duration of continuous use of the mark. Wide reputation of goods or service bearing the mark. Number of countries protecting the mark. Number of countries recognizing the mark as a well-known mark. Assignment price, licensing price, or investment capital contribution value of the mark. Compare with foreign legal regulation on criteria for evaluating a well-known trademark. In USA, the Lanham Act 1946, a mark is famous if it is widely recognized by the general consuming public of the United States as a designation of sort of the goods or services of the mark's owner. In determining whether a mark possesses the required size degree of recognition, the court may consider on relevant factors, including the following: the duration, extent, and geographic reach of advertising and publicity of the mark, whether advertised or publicized by the owner or third party, the amount, volume, and geographic extent of sale of goods or services offered under mark, the extent of actual recognition of the mark, whether the mark was registered under the Act of March 3, 1881, or the Act of February 20, 1905, or on the principal register. Account shall be taken of the following factors in established for a well-known mark. In China, trademark law of the People's Republic of China, reputation of the mark to the relevant public, time for continued use of the mark, consecutive time, extent, and geographical area of advertisement of the mark, records of protection of the mark as a well-known mark, and any other factors relevant to the reputation of the mark. Question 3. Reason the current status of the trademark related dispute. Distinguish counterfeit goods, poor quality goods, solutions. The current status of trademark related dispute. The intention of protecting registration of intellectual property foreign trademarks to be in trouble in Vietnam. Recognition of well-known trademark by a court merely rely upon the professional opinion delivered by another administrative authority. The intention. First story, a Vietnamese person usually looked for foreign products on the internet and found an extremely useful product, but it was unavailable in Vietnam. This person bought, and after researching it, the person decided to establish a company, register the product's trademark, decide protection, and proceed to manufacture the product. Because of its beneficial use, the product will easily enter into stores and e-commerce websites in Vietnam. After the foreign company had discovered that the Vietnamese product is the same as its product, it tried to contact and require the Vietnamese company to stop infringing its trademark and industrial design. However, the Vietnamese company replied that the product had been theirs and protected in Vietnam legally. Second story. This is a foreign company that transferred the rights of use, patent, and trademark of its professional manufacturing process to other countries. In Vietnam, this foreign company also permits exclusive right of use and exclusive license agreement to a Vietnamese company. In this license agreement, the foreign and Vietnamese companies are particularly shy. However, the Vietnamese company only had its signature without sealing. During the first 3-year period of the license agreement, the Vietnamese company sufficiently paid the foreign company the using fee. Accordingly, the Vietnamese company's products were manufactured based on the transfer formula and sold in Vietnam. However, after more than 1 year, the Vietnamese company did not pay the trademark using fee, which the foreign company had required many times. Nevertheless, the Vietnamese company refused to pay without specific reason. After investigating, the foreign company discovered that the Vietnamese company had arbitrarily registered the trademark in Vietnam and granted a trademark protection certificate, and that was a reason why that company had refused to pay the trademark using fee. Those are two of the situations that many foreign companies have faced related to the industrial property law (EPR) in Vietnam. Furthermore, the foreign companies in Vietnam struggle a lot against the resolution procedure of the intellectual property right dispute. Currently, Vietnam law has law on intellectual property 2005, amended 2009, stipulating subjects that belong to the IPR, including patent, industrial design, semiconductor, integrated circuit, disposition design, trademark, geographical indication. This group is only protected by the EPR if its subjects apply the registration form to the competent authority of the IPR and were granted the protection certificate. In addition, Vietnam is also a member of bilateral treaties such as a TRIPS agreement, marriage agreement concerning the international registration of marks, 1891, amended 1979, and other bilateral treaties. Therefore, when a foreign company decide to protect the IPR in Vietnam, they have the right to submit the registration of application to the IPR authority of Vietnam or register an international trademark under the merit system to require the protection in Vietnam and according with regulations of the treaty that Vietnam is also a member. Especially for famous trademarks, the IPR is established based on its use. So this type of trademark is non-compulsory to be registered. Recognition of well-known trademark by a court merely rely upon the professional opinion delivered by another administrative authority. Through the case Interbrand and Interbrand Corporation. In 2010, Interbrand Group, a UK group established in 1974, renowned for global brand search consultancy, most known for its global brand rankings, the plaintiff. So Interbrand Jones of company, Interbrand GSC, a Vietnamese company, before a Ho Chi Minh City-based court, the defendant, for illegally using the term Interbrand in Interbrand GSC business activities, including internet advertisement, unlawfully using Interbrand as its trade name and appropriating illegally using the TLD domain names interbrand.com.vn and interbrandvn.com.vn and accused Interbrand GSC of infringing its famous trademark Interbrand. In its official letter no. 5467 XHTTTKN, the Intellectual Property Office of Vietnam, VNYPO, responded to the court's inquiry saying that Interbrand is a well-known mark in Vietnam in 2006, and its reputation is widely known through the press and media. However, the court made a mistake because it failed to review the guidance for applicability of Section upon a Clause 3, Section 6 of the IP law in terms of the protection of unregistered famous trademark, not applying Section 75, but wholly based on the IPO's professional opinion to determine the trademark as a well-known trademark, is that the court took a reasonable opportunity away from the defendant so that he could defend and counter-argue the evidence proving the well-knownness of the plaintiff's trademark. It is essential to remember that the right to a well-known trademark in this case must be the right to unregistered well-known trademark. If the plaintiff's mark attained well-known status before March 21, 2006, the day on which the defendant trademark was filed, and this day is also temporarily resumed to be the day from which the defendant commenced using the junior trademark, but not the right to the plaintiff's trademark registration certificate no 146 017 issued on May 6, 2010. Distinguish counterfeit goods, poor quality goods. In general, counterfeit goods or imitation goods, poor quality goods are common calling from the perspective of the provisions of the law. They are generally defined as counterfeit goods of intellectual property according to the provision of Article 213 of the Intellectual Property Law. The intellectual property counterfeit goods are determined as follows: goods bearing counterfeit marks and goods bearing counterfeit geographical indications, defined in Clause 2 of this article, and paraded goods defined in Clause 3 of this article. Goods or their package bearing a mark or sign with identical with or indistinguishable from a mark or geographical indication currently protected for those very good without permission from the mark owner or organization managing the geographical indication. Could be made without permission from the copyright holder or related right holder. Solutions. According to the experience from the other country, the participation of enterprises owner of intellectual property rights in enforcement is very important. Vietnam's intellectual property law also stipulates that this is not only a right but also a responsibility of enterprises in coordinating and cooperating with law enforcement agencies. When a trademark is infringed, the owner needs to actively file a complaint or through a lawyer office to complain Intellectual Property Office of Vietnam. For customers, it is necessary to raise vigilance when buying goods or to be aware of their duties in combating imitation, counterfeit, or poor quality goods. This is not only to protect their rights, but also to fight against acts of subverting production and inhibiting the development of the country's economy. Vietnam now needs to establish a price between producers and customers. Accordingly, manufacturers need to spend money to notify customers in order to distinguish their real products from fake ones and held a timely reward policy for customers who discover counterfeit goods. Furthermore, there should also be a legal corridor set up by a customer protection association to protect customers after purchasing. Use product authentication solution to protect business as well as customer against the threat of counterfeit goods. Business and customer need to create closer links, providing continuous two-way information to avoid bad guys taking advantage of and affecting common interests. Conclusion: the fight against the problem of counterfeit goods and poor quality goods is not only the work of an organization or individual, but the work of the whole society. But first of all, business need to protect themselves. Customers need to be more knowledge in product evaluation and selection to take appropriate action. It is necessary to improve the provisions of the law, coordinate more closely between law enforcement agencies, and raise the awareness of organizations and individuals. Only by doing so will we step by step repair the problem of counterfeit goods and poor quality goods that are rampant today. Question 3. Find 3 judgments related to trademark dispute. Here are the 3 cases. In USA, Victoria's Secret, a registered trademark owned by Secret Catalog Incorporated, was filed in 1988 to market moderately priced, high-quality lingerie in stores designed to look like a woman's bedroom. In 1998, a weekly publication distributed to residents of Fort Knox, Kentucky, contained an ad for the grand opening of a store called Victoria's Secret that were owned by Victor and Kathy Messerly, which sold lingerie and other novelties and gifts. An Army colonel who saw the ad was offended by what he perceived to be an attempt to use a reputable company trademark to sell unwholesome tawdry merchandise and contacted Victoria's Secret, which then requested to Messerly to immediately discontinue the use of name Victoria's Secret and any variation thereof. In response, the Messerly changed the name of the store to Victoria's Little Secret. Unsatisfied with this name change, Victoria's Secret filed suit in the District Court for the Western District of Kentucky, alleging, among other claims, a violation of the FTDA. The District Court, noting that Messerly did not dispute that the trademark was famous, found in an unpublished opinion that the two names were sufficiently similar to cause delusion and that the Victoria's Secret mark diluted the Victoria's Secret mark through its tenanting effect. The court prohibited the Messerly from using the Victoria's Little Secret name because it tarnished the Victoria's Secret trademark. In Canada, the British Columbia Court of Appeal decision considered whether the use of keywords in online advertising constitutes passing off. The decision involved two post-secondary education institutions, the plaintiff, Vancouver Community College, a public institution, and the defendant, Vancouver Career College, a private institution. The plaintiff, Vancouver Community College, asserted common law trademark rights in VCC. The defendant, Vancouver Career College, used the domain name vcccollege.com for its website and purchased VCC as a keyword for the Google and Yahoo search engines. Users who search for VCC received a sponsor link to defendant's website which display the domain name college.com, the defendant's website did not display VCC. A user who clicked through the defendant's site would likely realize that the website was that of the defendant and not the plaintiff. Nevertheless, the plaintiff, inter alia, passing off of its common law trademark VCC and find evidence of confusion by prospective students. The Court of Appeal held that the proper time to assess this confusion was when the first impression with the confusing mark were made, which was at the time of user encounter is in the sponsor link. Confusion were not measured at the time a user clicked through to the landing page from the link. The appellate court considered this to be consistent with past decision of the Supreme Court of Canada, in that confusion should be assessed on the moment of first impression. Both levels of court agree that the mere purchasing of a competitor's trademark as a keyword for advertising were not sufficient to constitute passing off at that step along do not deliver a message to a customer. And the last, in Vietnam, the plaintiff in this case is Marvel Character Incorporated, a U.S. worldwide famous entertainment company, holder of copyright in and over a great number of famous works, including X-Men. The defendant is the IP Vietnam, the government authority in charge of intellectual property, which issued decision No. 805811 dated June 8, 2005 to grant a registration certificate for the trademark X-Men and Device in Class 3 in the name of International Consumer Products Company, ICP. ICP is the party having related rights and interests in the lawsuit. After examination, the IP Vietnam granted a registration certificate for the trademark X-Men and Device with respect to home use chemical cosmetic products in Class 3 in the name of ICP. On August 8, 2006, Marvel filed a request for cancellation of the above trademark registration in the name of ICP on the ground that it did not meet the requirement for protection at the time of filing. Specifically, it was identical with the well-known mark X-Men owned by Marvel. It was identical with the name and iconic image of X-Men characters under copyright held by Marvel. ICP took advantage of the reputation of the X-Men mark and X-Men character owned by Marvel in advertisement and marketing to cause confusion and deceive customers. However, Marvel requests were refused by the IP Vietnam under decision No. 93 dated January 22, 2008. In this agreement with the NOIP, Marvel filed an appeal against the NOIP's decision with the Ministry of Science and Technology, but it was also dismissed by the MOS under decision No. 1428 dated July 11, 2008. Marvel then decided to bring the IP Vietnam to the court for its decision to register the trademark X-Men and Device in the name of ICP, as its complaint was accepted by Hanoi People Court under the docket number 8 to 2010, dated October 8 to 2010. On March 29, 2013, the Administrative Court under Hanoi People Court opened the first instance trial, adjudicating the administrative lawsuit with the representative of Marvel Character Incorporated, the plaintiff of the IP Vietnam, the defendant, and of ICP, the party having related rights and interests. After reviewing the party arguments and evidence, the trial panel of the Administrative Court under Hanoi People Court has rendered the first instance verdict no 3 2013 hành chính sơ thẩm dated March 29, 2013 dismissing Marvel complaint, declaring valid the registration certificate no 634A1 for the trademark easement and device with respect to the goods in Class 3 in the name of ICP. This judgment has not been appealed and thus has become final and effective and enforceable. Let's move on to exercise 1.
Hello everyone, I'm Lam and I will talk about exercise 1. First, I will summarize the judgment. Plaintiff is the owner of the trademark 727 MP Xuân Lan for cosmetic product and copyright of cosmetic packaging work 727 Xuân Lan in Vietnam. The defendant produced the product on which the size 727 are fixed. The plaintiff requests the defendant to stop and case indefinitely on act of infringement upon the trademark of and copyright of the plaintiff. In any form, the defendant must publicly apologize to the plaintiff, correct the public information on the mass media, and compensate to the plaintiff with total compensation. According to the judgment of the first instance, the court accept the plaintiff request, force the defendant to stop on act of using the size 727 attached to cosmetic products in any form, publicly apologize to the plaintiff in a continuous newspaper of Tuổi Trẻ newspaper, Thanh Niên newspaper, Hồ Chí Minh City Law newspaper as required and compensate for damage to the plaintiff amount of 100,000 đồng. What is the subject of the dispute? The subject of the dispute is trademark ownership 727 MP Xuân Lan for cosmetic products and copyright of cosmetic packaging work 727 Xuân Lan in Vietnam. What are the conditions of protection of the mark? Xuân Lan Company was granted a certificate of trademark registration by the National Office of Intellectual Property 714588. The trademark belongs to Group 3 Cosmetic, Mask Powder, Curling Cream, Hairspray, Peeling, Face Cream, Shower Gel, French Powder. Xuân Lan Company was granted a certificate of trademark registration by the National Office of Intellectual Property 64378. Thus, the validity of the certificate was until the end of August 4, 2012. The total protected trademark include 727 Famous. Xuân Lan Company was granted a certificate of trademark registration by the National Office of Intellectual Property 69862 according to the decision No. A1012 dated the protected trademark include Xuân Lan 727 XL 727. This trademark belongs to group 3 of cosmetic. Mask powder, curling cream, hairspray, peeling, face cream, shoulder gel, friction powder. Determine the infringement. There have the infringement. In this case, Thandak company has infringed the trademark ownership rights of Songlang company and is in accordance with the provisions of Clause 1, Article 11 of Decree 105/26 NDCP of elements enriching the right to affix on labels, trademarks, the right attached to goods packaging, survivability, and etc. The next question, sanction for handling infringement. According to the first instance judgment, accept the plaintiff request forcing the defendant to stop on act of using the dye 727 attached to cosmetic products in any form, publicly apologize to the plaintiff in the continuous newspaper of Tuổi Trẻ, newspaper Thanh Niên, newspaper Hồ Chí Minh City Law, newspaper as required, compensation for damage to the plaintiff amount of 100,000 Vietnam đồng. The final question, compare with European and US law. First, in US law, a trademark owner who believes its mark is being infringed may file a civil action in either state court or federal court for trademark infringement, depending on the circumstance. However, in most cases, trademark owner choose to sue for infringement in federal court. Even when a plaintiff choose state court, it may be possible for the defendants to have the case removed to the federal court. If the trademark owner is able to prove infringement, available remedies may include the following: a court order injunction that the defendant stop using the accused mark, an order requiring the destruction or forfeiture of enriched articles, monetary relief, including defendant's profits, any damage sustained by the plaintiff, and the cost of the action, and an order that defendant, in certain case, by the plaintiff attorney fees. Conversely, in courts may find instead that you are not infringing the trademark. Defense bar a plaintiff claim or other reason exists why the trademark owner is not entitled to reveal. How do I know whether I'm infringing? To support a trademark infringement claim in court, a plaintiff must be proved that he owns a valid mark, that he had priority is right in the marks arsenal of the defendants, and that the defendant's mark is likely to cause confusion in the minds of consumer about the sort or sponsorship of the goods or service offered under the practice mark. When a plaintiff on a federal trademark restriction on the principles register, there is a legal presumption of the validity and ownership of the mark, as well as the exclusive rights to use the mark nationwide on or in conditions which the goods or service listed in the registration. This resumption may be respected in the court proceeding. Generally, the court will consider evidence addressing various factors to determine whether there is a likelihood of confusion among consumers. The case factors considered in smart case are the degree of similarity between the marks as issue and whether the purchase goods and services are sufficiently related that consumers are likely to assume that they come from a common source. Other factors and the cost typically consider include how and where the purchased goods or services are advertised, marketed, and shown. The purchasing conditions, the range of prospective purchase of the goods or service, whether there is any evidence of actual confusion caused by the allegedly infringement mark, the defendant's intent in adopting its mark, and the strength of the plaintiff mark. The particular factors, condition in a likelihood of confusion determination, as well as the way of those factors vary from the case to case, and the amount and quality of the evidence involved can have a significant impact on the outcome of the infringement lawsuit. In addition to claiming likelihood of confusions, a trademark owner may claim trademark exclusion, existing that is a famous mark, and the use of your mark diminishes the strength or value of the trademark owner mark by blur the mark distinctiveness, the mark image by connecting it to something distasteful or objectionable, even if there is no likelihood of confusions. The second is Europe law. The European Union created many copyright norms in multiple European Union directives that address copyright, which are implemented by member states, including the harmonization of the term of protection, the legal protection of software and database, the adaptation of copyright to the information society, and the enforcement of intellectual property rights. Depending on the type of material for which your company seeks protection, the relevant EU directive should be referenced. The EU Information Society Copyright Directive, for example, is a frequently referenced directive, as is similar in many ways to the Digital Millennium Copyright Act, which is the US copyright law that implements the WYPO. Both the US Act and EU Directive criminalize production and United States mission to the Europe Union Intellectual Property Toolkit, page 5. Dissemination of technology, device or service that use to circumvent measure that control access to copyright works and criminalize the act of circumventing an access control even when there is no enrichment of copyright itself. Both also heighten penalties for copyright enrichment on the internet. European copyright is enforced both civilly or administratively, while there are international agreements such as the Agreement on Trade-related aspects of the intellectual property rights that have the basic standard for effective IP enforcement produced under EU enforcement of intellectual property rights directive. Enforcement is a member state assume. Under the directive, member state must provide measures, procedures, and remedies necessary to ensure the enforcement. On EU member states must provide effective, dissuasive, and proportionate remedies and penalties against those engaged in counterfeiting and piracy. The aforementioned EU directive have led many states to adapt national provision on civil remedies more closely in line with best practice standard. These standards include procedural protection, which cover evidence and protection of evidence, and provisional measures such as injunction and seizure. This is all about question 1, and to be continued in question 2.
And now let's move on to exercise 2. 1. Summary of judgment. The plaintiff is Mr. Nga, defendant is Mr. Mạnh, because they do not have a business license but want to keep the lasting trademark with the logo created before. The plaintiff has an agreement with the defendants about having defendant act on his behalf in applying for a trademark protection license. The two parties have entered into an agreement to transfer trademark ownership to the plaintiff when he is eligible. And during that time, the respondent has a right to temporarily use the trademark. However, The defendant then evaluates the performance of the contract and for the arrest contract. In addition, the defendant also works an official respect to manipulate claiming that the plaintiff used his trademark and his company trademark were a fraud trademark. Therefore, the plaintiff filed a lawsuit asking the defendants to transfer trademark ownership as in the agreement and compensate for damages for losses imposed by the plaintiff's action. Based on the analysis of the evidence and testimony of many parties, after careful reasoning, the court made a decision to accept the plaintiff's request, trademark ownership as agreed, and dismiss the defendant's claim for damage. Question 2. What is the subject of this bill? In this case, the right to trademark protection and the recognition of the arrangement on the assessment and of the trademark protection are the subjects whose dispute Mr. Nga and Mr. Man agree over who is the owner of lasting trademark. At that time, however, the defendants were legal owner and use of the trademark. However, before that, the defendants were interested by the plaintiff to register for trademark protection in his name and agree on the transfer of trademark ownership to the plaintiff according to the agreement and was made into a contract. However, the defendant later changed his mind and said that the plaintiff were using a trademark to counterfeit his company trademark. So the subject in this dispute is who has the right to protect the lasting trademark and at community logging. Lesson 3. What are the conditions of protection of the mark? Trademarks are protected if the following conditions are met. First, a visible sign in the form of letter, words, drawing, images, including an hologram or a combination theory represented by one or more colors. These conditions is understood that the mark must be received and felt by the human eyes rather than being invisible looking at the offering the good label and seeing the trademark of that good in order to distinguish between them different intended from other goods and services. In other words, the brand must exist in the form of a certain material so that people can see it. To do so, the mark must exist in the form of work, images, drawing, or a combination of the above and be represented in one or more colors. Next, trademark must be capable of distinguishing the goods and services of the mark owner from the goods and services of their subjects, and must be considered to be distinctive if its mark of makeup one or more recognizable and memorable elements are from many elements that combine to form a recognizable and memorable whole, and is not part of the case of Law 2, Article 74 of the Intellectual Property Law. Easy to recognize and remember means that when observing, consumers can make an impression and keep it in their memory, and one who has seen it. Trademarks are easily recognizable and distinguishable from other brands. Next, trademarks falling into one of the following cases shall not be protected a trademark. 1. The third side identical or conversely similar to image of national flag in a place of other country. Side identical or confusingly similar to symbol, flag, badges, abbreviation, and full name of state agencies, political organization, social political organization, or major organizations, social professional management, social organization, social professional organization of Vietnam, and international organization without the permission of such agency or organization. Side identical or confusingly similar to real name, nicknames, shows dynamics, images of leaders, national heroes, characteristic of Vietnam or abroad. Side identical or confusingly similar to certification marks, inspection mark, or warranty marks of an international organization that such organization requests may not be used unless the organization has registered itself just mark a certification mark. And finally, side that mislead, confuse or deceive consumers about the origin, features, user quality, value, or other characteristics of goods or service. And move on. Question 4. Determine of infringement, if any. After studying and the verdict, it became clear that there were a violation. First, about the agreement to transfer trademark ownership between the plaintiff and the defendant. According to the statement of the plaintiff and the witness, there is a contractual agreement that requires the defendant to be responsible for transferring trademark ownership to the plaintiff as soon as he has a business license. During that process, the defendant added to the contract with a value of 3 months, but the plaintiff did not agree. The agreement contract consists of 2 sheets and 4 copies. However, when submitting evidence to the court, there were differences between the 2 contracts. Specifically, the contents of page 1 of the 2 different contracts. Defendant presented that because he thought that the contract expired after treatment, even thought it was not. He did not keep the contract and argued that the difference between the contracts could be due to applicant's mistake when drafting. Furthermore, the contract the defendant submitted to the court was a photocopy, and he could not identify who gave this copy to him. However, Mr. Mann later corrected his testimony that it was possible that the photo service has made a mistake. Page 1 of the contract provided to the court has many different from plaintiff's contracts, and even though different contracts, the rest on page 2, through many analysis and evaluation along with a testimony of witness when signing the contract, it showed that there's indeed a contract between the 2 parties related to the lasting trademark, and this contract is real. The contract provided by the plaintiff is an accepted endorsement contract, and middleman contract is invalid. At the same time, they aside that middleman intentionally fake pay one of the contracts which change to the arrangement of the two parties, including middleman claim that the contract's value in only treatment as one ownership of lasting treatment. In addition to the act of throwing evidence, middleman also has sworn statements. Specifically, he believed that the lasting trademark is his own invention and has registered for trademark protection for his products. He said that the contract arrangement between the two parties were about transferring his ownership to plaintiffs, not mentioning that he accepted to be the person to register for middleman's protection. They are also corrected in the contract they for. In addition, middleman also wrote an article despite to many places claiming that the plaintiff used his trademark and said that the plaintiff's goods were counterfeit trademark. This had affected the plaintiff's business, specifically several affected. However, he thought that the plaintiff used his trademark, so he wrote a letter notifying the customer and National Office of Industrial Property that the plaintiff's use affected and damaged his right. He asked the plaintiff to stop using it and pay him compensation. And question 5. Sanction for handling infringement compared with European and US law. The court ruled to recognize the contract arrangement between middleman and middleman. According to the content of the contract, it requires middleman and for the company to be responsible for carrying out the transfer procedure as agreed in the contract, and middleman does not have to pay middleman the transfer money as in middleman's first contract, because middleman has paid on expense in advance. If the defendants and the company still persist in not performing the transfer, the plaintiff has right to inform by contacting the National Office of Industrial Property to request the implementation of transfer procedure. Middleman and his company are jointly responsible for compensating middleman for damage caused by acts of infringement upon middleman's reputation and honor. On the other hand, the protection rights for the lasting treatment are still registered and honored by middleman. The protection rights has not yet been transferred to middleman. Therefore, the claim for compensation for loss of revenues were not accepted because he is still not the legal owner. So the damage caused by the trademark infringement did not occur. So with U.S. law, protection of trademark of a regional territorial nature. Therefore, even though a trademark has been registered for protection in Vietnam, it must still be registered in USA. Businesses have a responsibility to protect the ownership of their own trademark. Although government agencies can help business take steps to prevent any infringement, business should actively monitor to detect any unauthorized use the trademark. If the business believes that an individual or another business has illegally used its trademark, intellectual property law in general and trademark law in particular in the United States is complex and should only be used when the other enforcement method cannot prevent infringement. With European law, there is a free trade arrangement between the European Union and Vietnam, EVFTA, which contains proceedings on the enforcement of intellectual property rights. Europe is the world's leading importer of intellectual property products, so there is a need to strengthen protection as well as enforce the protection of intellectual property rights. The EU also has a specific protection regime for geographical indications and pay great attention to protection of this type of intellectual property right. European trademark conditions are similar to those in Vietnam laws. First, indistinguishable signs such as symbol shape and geometry, numerous letters, and letters with no meaning or pronunciation. Signs intended to deceive consumers about origin, feature, use, or quality of the goods. Signs indicating the time, place of production, the common name of the produce. The rights to the mark are established on the basis and registration as the competent authority. An application for registration of a trademark will be refused protection of the mark if it is incapable of performing the distinguishing function of the mark. The gesture is to symbol descriptive of goods considered with the sign with the distinctive function of the mark. Common are identical with the name symbols of countries, organizations, business people are identical are confusedly similar to other people's trademarks that have been registered or filed early are considered well known or widely recognized are identical to or similar to objects already under the rights of others, including trade name, geographical indication, industrial design, copyright, and so on.
Okay, so I will continue the rest of the presentation. So the question 3 is to analyze the article Havard as a model in trademark and domain name protection. So I have read this article and here is some of the main issues that I gathered. Sorry, okay, proceed. First is the legal protection of trademarks in the United States. Second is Havard's new guidelines concerning the use of university names in the electronic arena. Thirdly, recent lawsuits that Havard has involved in and yet won. Reasons for Havard's success in trademark and domain name protection in such legal proceedings. And lastly, potentials in adapting Havard's policy in other schools in the United States and other schools worldwide. So let's talk about the first thing, legal protection. So in terms of statutory protection, federal state statutory protection of trademarks developed from the common law. And the Trademark Act 1976, which was amended in 1988, and it's often known as the Lanham Act, governs federal trademark law. To receive protection of their exclusive rights to use a mark nationwide against subsequent users of the mark for related products and services, trademark owners must federally register their marks with the United States Patent and Trademark Office, also called USPTO. Trademark infringement is the reproduction, counterfeiting, copying, or imitation in commerce of a registered mark in connection with the sale, offering for sale, distribution, or advertising of any goods or services on or in connection with such use is likely to cause confusion or to cause mistake or to deceive without the consent of the registrants. Besides, the Federal Trademarks Dilution Act 1995 provides a cause of action for owners who believe that another's conduct harms their own famous marks. In Section 43, Clause C, offers a claim for dilution, which means the lessening of the capacity of a famous mark to identify and distinguish goods or services, regardless of presence or absence of competition between the owner of the famous mark and other parties. Not just that, the United States legal system also provides a shield to protect domain names. In particular, the Anti-Cyber-Squatting Consumer Protection Act has issued some of the followings. The ACPA provided trademark owners with new ammunition by offering a powerful way to frustrate cyber squatters who harm American customers, businesses in the future electronic commerce. In terms of case law protection, courts first recognized colleges and universities' protectable interest in their names and insignia in 1930. And when it comes to case law protection in terms of universities or colleges' trademarks, it would be amiss if we're not going to talk about the three famous cases. The first one is Trustees of Columbia University versus ANSEC Field. The New York Supreme Court concluded that the defendants called their educational service Columbia Educational Institute to intentionally lead the public to believe that it was the same as or affiliated with Columbia University. Starting that, the defendants could not adopt the great name and standing among the educational institutions of the country anymore that Columbia had acquired. The court granted injunctive relief to the university. The second case is the Cornell University versus Messing Bakeries. The New York Supreme Court Appellate Division explained that an educational institution that has invested a great deal of time, effort, and money to earn public praise ought not against its will have the prestige diluted by a commercial use of its name, suggesting connection or benefit to the institution from the enterprise. The court upheld a finding that a baker who relieved on a recipe developed by a Cornell University professors make bread, which later marketed as Cornell recipe bread, negatively impacted the university's rights. The court ultimately ruled that the defendant could not use the name Cornell without permissions from Cornell University anymore. Although specific holdings vary, the courts have consistently reaffirmed the public that the basic principle established in those two landmark cases. Secondly, Havard's new guidelines concerning use of the university's name in electronic arena. On April 18, 2000, Havard's provost, Harvey V. Finberg, issued new guidelines for using Havard names in web pages, domain names, and email addresses in response to the many inquiries that had received regarding such matter. The latest version of the school's policy, posted online in December 2000, informs the public so clearly that people who wish to use the Havard name in any form, in an internet address, an email address, or a website identification, must receive advance permission from the appropriate official. Thus, the school's provost must agree to use of Havard, and in the case of particular school's name, the dean of that school must grant approval. Havard makes it so clear that electronic communication or activity is treated similarly to other activities which require advance permission for the use of the university's name or insignias. This policy also includes new guidelines for suitable domain names. Those who use domain names that feature a Harvard name must make sure that the domain names correctly depict the activity or program to which they refer. Also, .edu or .org will be the subtable domain for most activities. Explicitly approval by the provost is necessary for registration of domain names in .com or .net. Next, we have recent lawsuits that Havard has involved in and definitely won. The first case is Havard College versus Rehis. The school sued Michael Rehis, or the defendant, for cyber piracy 1 week after the ICPA's enactment. The complaint alleged trademark dilution, trademark infringement, cyber piracy, unfair competition, and related state law violations. Havard sought preliminary and permanent injunctions and accounting of profits earned from the infringing and diluting activities, and destruction of all infringing and diluting goods. A consent judgment was issued on March 14, 2000. The court required Rehis to remove all references to Havard's marks from his websites, to immediately cancel the registrations for the infringing and diluting domain names, to supply lists of domain names containing Havard's marks, which he registered, regardless of whether he currently owned them, and lastly, to turn over all materials which contained Havard's marks and which he possessed or controlled. Thus, one of the first party to bring a lawsuit under the ICPA prevailed. Next one is Havard College versus eSchool. It all began when eSchool failed to secure federal registration for its trademark and domain name. Much to the money's dismay, the USPTO determined that consumers would likely to confuse the website not Havard with Havard because the marks and the entity's services were so similar. eSchool predicted that Havard would not bring lawsuit as it did with others. But Havard then sued eSchool on July 31st, 2000, alleging trademark infringement, trademark dilution, false designation of origin, unfair competition, and cyber piracy. Havard requested preliminary and permanent injunctive relief as well as damages to support a finding of likelihood of confusion and prevail on its trademark infringement claim. Havard asserted that the Havard mark was famous and thus extremely strong, and that this mark and the not Havard mark were basically identical, except for the word not, which is generic and does not distinguish them. The defendant also argued that Havard could not meet the substantial similarity elements of such a cause of action for dilution. eSchool claimed that certain features of its not Havard.com mark, such as the word not, boldly featured in red and the .com ending sufficiently distinguished it from Havard's. Eventually, Havard secured preliminary injunctive relief against eSchool on September 25th, 2000. Then, on October 2000, the starting date of the trial, Havard settled with eSchool, and eSchool agreed to acknowledge that its prior use of not Havard.com had diluted and infringed Havard mark. It also promised to transfer ownership of the name to Havard by December 15th. Finally, the startup company consented to abandon the trademark applications it had filed with the USPTO regarding domain names that contained Havard. The settlement did not award damages to the university, which ultimately had decided not to pursue such relief in the hopes that doing so would result in a swifter resolution of the conflict. Havard entered into litigation against eSchool with foresight, as evidenced by its pledge to continue the suit even after eSchool changed its name to Powered.com. Havard maintained its dedication to long-term protection of its domain names. Next is the reasons for Havard's success in trademark and domain name protection at trials. Havard is the oldest and yet the most prestigious educational institution in the world. It also is among the most ardent protectors of trademarks and domain names. Adopting various methods to trademark and domain name protection, Havard serves as a paradigm for fellow colleges and universities to look it up and imitate its moves. Firstly, the school uses all the tools at its disposal to preserve the fruits of centuries of successful promotion of its reputation for excellence. Havard sued cyber piracy 1 week after the ICPA was enacted. It has relied on the statute ever since as another means to preserve its good name. Although the school does not hesitate to bring lawsuits when necessary, it tries to resolve disputes effectively as evidenced by recent cases. Secondly, Havard also regularly reviews its policies regarding use of university names, and it adapts them to its changing needs. Eventually, Havard's recently issued guidelines concerning the use of Havard's names in electronic contexts is consistent with guidelines addressing their use in other situations. These features will cut down on unintentional misuse of Havard's marks while simultaneously supporting Havard's arguments of alleged infringers' bad faith, which is requirement for claims under the ICPA. With such an easy, understandably going policy, defendants will have a very difficult time convincing a court that they did not intend to dilute or infringe upon Havard's domain names. The last part, we will discuss potentials in adapting Havard's policies in other schools within the US and even worldwide. Most schools do not have available options to them as many choices for domain name protection as Havard because they have fewer financial resources, nor they can afford to utilize the avenues that are open to them as frequently. However, they still can learn much from Havard's strategy. Colleges and universities facing continuous pressure to gain recognition may forget the importance of safeguarding the good reputation they have earned. They need to devote more time and money to trademark protection, which now embraces their ever-expanding internet arena. Next, all schools can strengthen their trademark policy as Havard has done and continues to do so. If these documents or policies or charter, you might call it, are thorough enough and yet at the same time comprehensible, they can serve as solid foundations for trademark and domain protection. The periodic review and revision of policy statements probably will not prove too much burdensome, especially considering the benefits derived. Given the crucial role that trademark offices play in safeguarding names, marks, and domain names, no universities or colleges should be without one. In this manner, colleges and universities must see to it that litigation serves as a viable option for domain name protection as long as they have well-published, thought-out policies to protect their trademark and domain names. So, thanks for your attention to our presentation today. This is the end of our group's presentation. So please, if you have any questions, just give me a hint. Thanks to you very much.
Thầy ơi, em xong rồi đó thầy.
Okay, thank you. So it's time for question. Sao? Không ai hỏi hết hả? So I have only one small question. So what is the main difference between the trademark and the trade name? And why we need to have the trade name protection? And then the second question is the domain name. Why don't we protect the domain name as a trademark? Sao nhớ nghe được câu hỏi không ạ?
Dạ được thầy. Tổng cộng là hai câu là khác biệt giữa trademark và trade name. Rồi tại sao phải bảo vệ trade name? Câu thứ hai là tại sao cái domain name nó phải được bảo vệ như là trade name, đúng không?
Tại sao lại chúng ta lại không bảo hộ cái domain name như là một cái trademark? Cái tên miền website á, tại sao chúng ta không bảo hộ cái tên miền đó như là một cái trademark? Ở bên room chat thì như có hai bạn có câu hỏi.
Dạ tụi em thấy thì
Alo, Tú ơi.
Mình thấy rồi.
Mình trả lời nha. Tú ok chưa?
Ok nha Lâm.
Tường Vi, I wrote down the answers to your question. And if you have any doubts about it, you could ask me.
Thank you, your answer.
And first, to answer for the question, if different of trademark and trade name, it can be said that trademark and trade name are two completely different objects in nature. Is it possible to distinguish based on some basic characteristics such as a trademark is a sign used to distinguish and a trade name is a name. Um, a trademark can be word, images, symbols, a combination of language and image. A trade name is a name, just a sign of the word. Trademark has the functions of distinguishing goods and service, uh, and the trade name having the function of distinguishing business entities in the same phase and area. Mm, a business entity can register multiple trademarks for different types of goods and services. However, a business entity can only have one trade name. And that's in my group questions.
Ok, thank you. Rồi, các em có muốn hỏi, có muốn nói gì nữa không nào? Tường Vi có hỏi một câu kìa.
Tường Vi ơi, can I ask you a question? You say like be cancelled by others. You mean like other commercial entities or like courts or administrative institutions?
Cái này là trả lời dựa theo luật Việt Nam á, ý là
Không biết là by others tức là bà muốn hỏi là mấy cái
Tức
thương nhân
là-
khác hay là cơ quan công quyền nhà nước vân vân.
bị người khác, tức là những người khác á, thương nhân khác yêu cầu hủy.
À, hiểu rồi, hiểu rồi, hiểu rồi. Thầy ơi, hồi nãy câu hỏi của thầy là tại sao domain name nó không được bảo hộ như là trademark hay là như là trade name thầy?
Không được bảo hộ luôn.
Không được bảo hộ luôn.
Ừ.
Cảm ơn câu trả lời của bạn Thư.
Sao? Trả lời qua bên group cho thầy nhé.
Dạ vâng ạ.
Nhóm trả lời qua group cho thầy nha.
Dạ vâng, dạ vâng.
Ok.
Dạ, chỉ còn một câu cuối cùng là câu tên miền nữa thôi đúng không thầy?
Ừ.
Dạ nhóm em còn của thầy là một câu tên miền nữa thôi.
Ok. Còn cái câu nào bên chat room nữa bạn chép qua nha.
Dạ vâng,
Dạ.
còn một câu của bạn Khánh Linh nữa rồi.
Còn câu Khánh Linh.
Chép qua bên group, trả lời bên group luôn được.
Dạ vâng, dạ vâng.
Ok. Thầy sẽ chốt cái bài ở đây nha. Đợi tí. All right, so I will make some resume for the lesson today. Yeah, so first of all, thank you again for your group presentation. It's also very informative and very colorful. So we are on the section 8, a discussion of section 8. So the purpose of this section, we're going to research more about the trademark and understand more about the trademark, especially for the well-known trademark under the intellectual property law. And of course, the well-known trademark is a very special one. Very special one. They have very special legal status of the well-known trademark. So will make them very different to other normal trademark. The influence is bigger. The procedure for recognition is also very different. And then we have seen some litigation in practice. So you can see how the Vietnamese court, they will resolve the case. You have more experience to resolve the case concerning the trademark in future, especially very interesting case concerned to the Marvel character. As you can see that relates to the US law and Vietnamese law in order to resolve the case. And lastly, concerned to the trade domain name protection trademark of Harvard University. So you can see how very famous university they can deal with problems of the infringement to their name, and how can they protect it under the intellectual property law, especially for the trademark law. So in the future, maybe there are some litigation like this, and you will have the experience to resolve the case. Okay, so that's all for today. We have successfully complete the trademark litigation for today. Ok, nếu em không có câu hỏi gì thì nữa thì chúng ta sẽ chào tạm biệt ở đây nhé.
Thầy ơi, em có câu hỏi này.
Xin mời.
Thầy cho em hỏi những cái quán phở như là phở Lý Quốc Sư hay là cái bún chả Obama thì nó có vi phạm cái khoản 3 điều 73 không thầy? Cái anh hùng dân tộc doanh nhân Việt Nam nước ngoài vậy thầy.
Tùy thuộc thôi. Bây giờ đầu tiên là gì? Đầu tiên là họ có đăng ký không? Đúng không? Phải check xem là những quán phở đã đăng ký chưa. Thì khi mà đăng ký thì mới làm gì? Phát sinh hiệu lực thì lúc đó họ mới có cơ sở để refuse cái việc đăng ký đó. Còn nếu không thì họ sẽ kiện theo một cái quy định khác mà không có kiện theo quy định về luật sở trí tuệ được. Em mình chưa không? Trước mở mic nói nghe không nghe nhé.
Dạ vâng. Dạ là phải tùy trường hợp xem có vi phạm đó thầy.
Đúng. Nếu muốn kiện về sở trí tuệ thì trước tiên nó phải là một đối tượng của sở trí tuệ đó. Như vậy thì rõ ràng là em thấy là gì cũng biết là họ có đăng ký chưa. Nếu mà đăng ký thì có thể là nhà nước sẽ ra một cái quy trình gọi là hủy bỏ hiệu lực ha. Khi mà những cái domain name này kia họ không trademark không đáp ứng những điều kiện nhất định. Còn nếu mà phạm vi nhỏ, phạm vi kinh doanh nhỏ thì họ vẫn cứ để như vậy. Nó là một cái tên thân quen, một cái tên bình thường để ăn uống này kia. Nhưng mà khi kinh doanh, ví dụ như franchise đi, hay là kinh doanh những cái nhãn hiệu ra nước ngoài thì lúc đó mới đặt lên gì? Cái vấn đề là có vi phạm hay không. Còn nếu không thì họ vẫn thả nổi như vậy. Em hình dung chưa?
Dạ vâng.
Đó, cho nên sẽ có nhiều trường hợp. Có nhiều trường hợp là sẽ gì? Những cái trường hợp đó thì có thể là hành vi xâm phạm đó. Nhưng mức độ là nhỏ lẻ, mức độ là cái quy mô ảnh hưởng kinh tế nó không tới đâu hết. Đó, cho nên họ cứ thả như vậy. Đó. Đến khi họ muốn mở rộng kinh doanh này kia ra hàng trăm, hàng ngàn tiệm, đó. Như vậy họ phải register, phải đi đăng ký. Mà đi đăng ký thì có thể là họ sẽ vấp phải những cái là bị refuse. Hoặc ví dụ có một công ty nước ngoài họ cũng kinh doanh lên bữa đó, họ sẽ gì? Sue bằng một cái civil case. Đó. Còn ngoài ra thì em chỉ có thể là sử dụng những chế tài khác, ví dụ như competition law hoặc administrative law. Ok chưa Đức?
Dạ vâng.
Đó, nó là như vậy. Nếu mà muốn kiện theo sở hữu trí tuệ thì nó phải là một đối tượng, nó phải có hiệu lực, nó phải có giấy chứng nhận này kia, chúng ta mới xử lý được cái đó được. Còn nếu không thì người ta sử dụng những chế tài khác. Một cái chế tài mà người ta hay sử dụng đó là cái competition law. Và trong luật sở hữu trí tuệ là một điều 130 đấy. Ok. Rồi, em có câu hỏi gì nữa không nào? Nếu không có câu hỏi gì nữa thì chào tạm biệt các em nhé. Chúc các em một buổi tối thật là vui vẻ nha.
Yeah, see